good. All right, welcome to our debate entitled Resolved, the Supreme Court Should Overrule Qualified Immunity. With me are two individuals who are going to debate this. On my right is Will Baude from the University of Chicago, who is a graduate of Yale Law School and clerked for Judge Michael McConnell and Chief Justice Roberts. To my left, geographically, is Chris Walker from Ohio State, who attended Stanford Law School and then clerked for Alex Kaczynski and Justice Anthony Kennedy. Both of these scholars have written extensively on constitutional law, administrative law, and issues of federal courts, and they have written extensively on the topic of our debate today, qualified immunity. All right, I know that some of you in the room are federal courts teachers and scholars, but for those of you who are not, who have not been ensconced in this doctrine for quite some time, I want to give a little bit of a background on what qualified immunity is. So this is a defense that comes up when an individual sues a government official. It could be a federal official, a state official, or a local official, saying that that person violated the individual's federal rights, typically constitutional rights. Now, I think most of the time when we hear somebody's violated your rights, well, an individual should be able to bring suit and get money damages for a violation of his or her rights. Well, qualified immunity takes the situation and looks at it from the defendant's perspective. As I'm sure all of you remember from your constitutional law courses, a lot of the Supreme Court's doctrine is not entirely clear. And the idea of qualified immunity is they look at the government official and say, would you reasonably have thought you were violating somebody's rights in this context? And so qualified immunity says the government official is only going to be liable for money damages if, one, there is in fact a constitutional violation on these facts, and two, that constitutional right was clearly established at the time of the defendant's conduct. The idea is that you should not be liable for money damages unless you were on notice of having violated somebody's rights. So that's just a brief introduction into the doctrine. As with any doctrine, the devil is in the details. And our two debaters today are going to tell you why those details either require getting rid of qualified immunity or perhaps keeping it perhaps in a modified form. So with that, we're going to start off with our first debater, Will Baude.
Great, thank you, Tara. So the doctrine of qualified immunity that Tara just told you about has been widely criticized on a lot of different grounds. Some people say that the doctrine leads to widespread misbehavior by government officials who no longer have adequate deterrence to ensure that they obey constitutional rights. Some people say it means that we just have a sort of stagnation in the development of constitutional doctrine because courts rarely ever decide whether conduct is constitutional or not. They just award the government official immunity. They say the doctrine is unclear, and then they leave it unclear. So the next time, the doctrine remains unclear, and again, nothing happens. Others have done sort of more on-the-ground research just to point out that virtually every official that's sued for these kinds of civil rights claims is indemnified, either by their government employer or by an insurance company. So they're not the idea that this doctrine is going to sort of protect officials from unfair liability isn't really true. What we're really doing is ensuring that nobody in the government has to pay the price for violating constitutional rights and ensuring that the costs fall on victims rather than society at large. And I'm not going to talk about these arguments very much because one of my frustrations is that the Supreme Court has basically ignored them all and failed to engage with them. That would make sense, the Supreme Court's behavior, if qualified immunity were some sort of legal doctrine that were imposed by Congress in a duly enacted statute that the courts are supposed to obey and leave to Congress the decision of whether it's a good idea or not. But that's not at all true. Congress has never passed or told the courts to enforce anything like qualified immunity. On the contrary, Congress passed a civil rights statute shortly after the Civil War, 42 U.S.C. 1983, the Ku Klux Klan Act, that says that anybody who acts under color of state law should be held liable for damages or other remedies to the person whose rights they violated. It's a straightforward civil rights, constitutional rights enforcement statute that says if your constitutional rights are violated by a state actor, you can go sue them. That's what Congress has said. The Supreme Court is the one in the past 52 years now that's added this doctrine of qualified immunity to what I would say is our sort of duly enacted law of the land. And in a series of cases, the Supreme Court has said, well, this statute doesn't mean what it says, and instead we should add to it a kind of unwritten doctrine that means in almost all cases, government officials can't actually be sued for money damages. And the court, to its credit, has gone to some lengths to try to explain why it can do this and where this doctrine comes from. But none of these justifications actually hold up under serious scrutiny. So the leading justification that the court has offered is a sort of historical idea that when Congress enacted this statute, when Congress created the Civil Rights Statute, they were acting against a sort of common law backdrop of lots of common law rules of procedure and immunity and defenses, and surely they didn't mean to wipe them all away. And so one of those doctrines might have been qualified immunity, and it might sort of sit out there as a kind of unwritten historical defense to a duly enacted federal statute. But this is just not true. So when you dig in historically into what civil rights litigation looked like in the 19th century, there wasn't anything like the modern doctrine of qualified immunity. There were sort of immunities for legislators, for prosecutors, maybe not actually, for judges, for kind of a few kinds of special purpose officials. But this sort of general idea that government officials can violate the Constitution, but do so with impunity as long as the violation was kind of unclear, is a 20th century innovation. On the contrary, there are lots of examples of the courts enforcing constitutional rights and saying, we're aware this is a slightly harsh result, that this official might not have realized that what he was doing was unlawful, but when you violate the Constitution, you do so at your peril. The Constitution is the highest law, and our job as courts is to enforce it. And if the legislature wants to provide for indemnification or some kind of modification to help the officer, that's fine. But it's not our job as courts to do anything other than to enforce the law. I'm oversimplifying several hundred, maybe 1,000 pages of historical research when I say all this, and I'm sure somebody will ask me about it. Some of you have probably done some of that work in this room. So there is some changes in tort law over the course of the 19th century where courts sometimes do recognize a sort of good faith defense when officers are sued in certain contexts for a wrongful arrest, for other things. It's not a regime of totally strict liability. But those defenses operated as part of the sort of ordinary common law of torts, and usually in a very sort of tort-specific way. So we might say, sure, a wrongful arrest, police officers might arrest you and get the wrong guy. That doesn't mean they violated the Constitution. So long as they had probable cause, the seizure might still have been reasonable. We go through each constitutional right. So I'm not saying there's a regime of exactly strict liability. But what the regime was the court's job was just to figure out what did the Constitution actually mean? Did the officer violate it? And if so, they would enforce it rather than sort of invent some exception to that. There's just not a lot of historical basis for anything like the modern doctrine of qualified immunity. Now, to their credit, some of the Supreme Court justices have admitted this. Justice Thomas and the late Justice Scalia, for example, had an opinion where they said qualified immunity as it exists today is pretty much a made-up doctrine. But they said that's okay because Section 1983, the Civil Rights Statute as it exists today, is pretty much a made-up statute. Which brings us to the sort of second line of defense the Supreme Court has offered. And with defenses like these, I don't know, I'm not sure you need enemies. But what Justice Thomas and Justice Scalia said is, we actually made a huge mistake in interpreting the scope of civil rights liability in the first place in a 1960s case called Monroe versus Pape, where the court decided for the first time that officers who violate state law can still be state actors. So when the police break into your house in the middle of the night without a warrant, without a good reason, and roust you out or shoot you without probable cause, that's a constitutional violation. It's also murder, trespass, a violation of a bunch of ordinary state law. So some people had argued when police officers do that, do something so flagrantly illegal, they actually become no longer government officials at all. They get out of constitutional liability because they're acting so illegally that they're not really attributable to the state. In Monroe versus Pape, the Supreme Court disagreed with this and said no, as long as they're wearing guns and badges and clothing themselves in the authority of the state, that's enough for them to be acting under color of state law and to be held liable. But if you disagree with that, and you think that we've had way too much sort of civil rights enforcement because of this mistaken case, maybe you defend qualified immunity on the grounds that it's kind of a two wrongs make a right situation. We've got liability we shouldn't have had, so we invent an immunity we shouldn't have had and hope it all kind of evens out in the wash. Two problems with this defense. One, Monroe versus Pape is not wrong, it's right. The Section 1983 refers to people who act under color of state law, not just people who act consistently with state law. And the phrase under color of law, authority, et cetera, goes back to medieval England as the way of referring to this kind of problem. Somebody who's going around brandishing state authority, even if they may not actually have it. Somebody who's got a badge and a gun is trying to arrest you, whether they're supposed to be able to arrest you or not. And there are even specific references to this in the enactment of Section 1983. So I'm not at all convinced there was a mistake here that needed correcting. But even if there were, this sort of qualified immunity is a really strange way to do it. So what qualified immunity does is it applies to every kind of claim, every kind of constitutional claim, as Tara mentioned, even non-constitutional claims, regardless of whether they are ones that everybody agrees would have been brought, you could have brought at the founding, or ones that are, rely more on some sort of modern doctrine or modern procedural rule. And it treats them all equally unkindly and cuts them all down across the board. So if you tried to actually be faithful to what these sort of second best theorists would want, you should want a regime. This is what Justice Frankfurter proposed in his dissent in Roe v. Pape, where the idea would be something like this. When a state officer violates your rights, you should first go sue him in state court for a common law claim, trespass, whatever it is that they did to you. And if the state court gives you a remedy, great. You don't need a federal remedy. You've been given a state remedy. Everything's taken care of. If the state clothes their officer in some kind of immunity, refuses to let you bring a common law suit, well, now they've sort of claimed the officer, they've adopted the officer as a state actor, and you can go sue them in federal court. You've always got some kind of forum, state court or federal court, and we could bargain out which one. That's what the sort of two wrongs make a right people ought to be proposing. Instead, we get qualified immunity. We have some sort of state immunity that stops you from suing the officer in state court. You have a parallel federal immunity that stops you from suing them in federal court. And rather than saying, well, you have your rights somewhere and it's a question of which forum, we just cut them off everywhere. So it's more like two wrongs just still make a wrong. Like the fact that a decision is kind of in the opposite direction of a decision you might think is wrong doesn't necessarily mean you get closer to the original starting point. Sometimes you can just wander off in a sort of extended diagonal even further from any kind of appropriate legal answer. The third rationale that the court has put forward, and this I think is the most obscure, although it may actually be the most defensible, is to say that qualified immunity is something like the rule of lenity, or the idea that penal statutes should be strictly construed. So if you look at this from the point of view of the officer, rather than the point of view of the citizen, and judges are predisposed to look at things from the point of view of the government official, rather than the point of view of the ordinary citizen. If you look at it from the officer's point of view, it's not fair to hold them liable to something that they couldn't fully have expected. So if we imagine a case where it's before Obergefell is decided, or it's before even Windsor is decided, and some state official doesn't know that same-sex marriage is going to be a constitutional right soon, maybe it's unfair to subject them to this kind of retroactive liability for something that hasn't yet happened. The same way we might not want to lock people up in jail for something they couldn't have known was illegal. Maybe. I will say, so criminal defendants try the same move. They try to say, look, the law was somewhat unclear, so you shouldn't be able to convict me for this aggressive interpretation of the wire fraud statute, the perjury statute, or one of the other many federal crimes. And the courts regularly laugh it out of court. In fact, the very same move that the court has confronted this move for officers, where an officer will say something like, look, the Ninth Circuit said this was illegal, but the 11th Circuit said this was perfectly fine. How could you expect me to second guess 3 fine judges in the 11th Circuit? And the Supreme Court will say that is almost per se qualified immunity. If an appellate court has said that it's okay, and there's a circuit split, then how can we expect an officer to do any better? Try that one as a criminal defendant, and they do, and the court says, well, you should have been on notice that at least some judges thought the conduct was illegal, so you can't just rely on the fact that a lot of judges thought the conduct was legal and you get locked up. And the court regularly treats ordinary citizens much, much worse than government officials. So I'm not sure how far this analogy can get anybody. And I just think, so if you look at any of these doctrines, none of them add up to anything like our current doctrine of qualified immunity. Just one last thing. So in very recent years, Justice Thomas has said that in an appropriate case, we should reconsider our qualified immunity jurisprudence. In an even more recent case, Justice Sotomayor described qualified immunity as an absolute shield with nothing right or just under the law about it that should be reconsidered. I submit that if Justice Thomas and Justice Sotomayor agree about something, they're probably right.
I have to say it is quite an honor to be on the stage with Tara Grove and Will Baude, two of the leading scholars in federal courts and constitutional law of my generation, and might be the leading by the time our generation is done. So it's a real honor. I'm not a historian. I'm not a constitutional law scholar. I've taught fed courts maybe once, not very well. I'm a simple administrative law professor. But I care a lot about qualified immunity because it interacts, obviously, with administrative law. It's another way to control and rein in government action. Why I'm on this panel, I think FedSoc Googled defend qualified immunity, and this is the only thing that came up. The Notre Dame Law Review essay that Aaron Nilsson and I wrote. Aaron Nilsson and I drew lots, and I got the short end. And so I'm here to defend qualified immunity. But I think I'm right. And I'm going to kind of focus on 4 points in kind of these introductory remarks. And the first is the one that I think we'll try to hint to at the end, which is stare decisis. And to channel Justice Gorsuch in his confirmation hearing, qualified immunity is a doctrine. It's a precedent of the United States Supreme Court. It's been around for over 50 years, first in Pearson v. Ray at least. It has been reaffirmed many, many, many times. In fact, it's been reaffirmed in what Will calls the shadow docket through summary reversals, in the sense that it's so clear and so well established, you don't even have to have merits briefing and argument for it. It's a well-established doctrine of the Supreme Court. More importantly, for our purposes, it's not a constitutional ruling, it's a statutory interpretation. And so statutory stare decisis applies, and that carries extra weight when we're looking at this. I'm going to return to that at the end and try to give you my Article 1 judicial conservative pitch on why we don't want to just be overruling every statutory interpretation decision that we see in sight. But the Congress has dealt with this a number of times. In 1983, Congress amended Section 1983. This was, 15, 16 years after Pearson, to change the types of immunities that apply to judges. Did not touch qualified immunity. It has also adopted qualified immunity in other contexts and statutes, so clearly is aware of the doctrine and is legislating against its backdrop. These arguments made me feel a little nervous because I'm not a huge legislative history fan, but when it comes to understanding statutory stare decisis, they're very important. That Congress knows about this backdrop, that it's been legislated against that backdrop for a very long time. And so that's kind of the stare decisis argument that's there. Now, Will has some responses. One, and we might get to this more in the Q&A, maybe the real problem we have with this isn't qualified immunity as it was originally kind of conceived in 1967, but Harlow versus Fitzgerald that removed the subjective reasonableness inquiry from it. My response to that is, well, if you push me hard, I might agree, but it is 35 years old now. It has been repeatedly affirmed by the Supreme Court, and I don't see the statutory stare decisis argument being much different there than it is for the original version of qualified immunity. The second argument that Will raises is that qualified immunity has changed. The Supreme Court has tinkered with it in the context of Saussure and Pearson. Now, Will and I both clerked on the Supreme Court the year Pearson was decided. I think it was rightly decided when Justice Alito wrote for the court to get rid of the requirement that they had to decide the constitutional question first before saying that it was not clearly established. My response to that is that's the procedural mechanics of judicial decision-making. That's not the substantive defense of qualified immunity. It's a very, very different thing, and I'm happy to go into that more in the Q&A if that's something we want to explore. So my first answer, which Jack Berryman has informed me is not a good answer, is statutory stare decisis should control. We should let Congress make this decision. The second answer is the history, and I'm really nervous about this. I'm not a historian. I have not spent as much time as Will has reading through the thousands of pages of cases, but I'm not at all convinced that Will's right. He might be right. I'm not convinced he's right. We both agree, apparently, that the Section 1983 incorporated the backdrop principles of common law defenses, I think. At the beginning of your conversation, I thought maybe you were kind of walking away from that, but in your paper, I think you agree with that, right? And we know at the time of 1871, there were common law and statutory defenses. One of the kind of classic ones that the Supreme Court brought back up in the Heinen versus North Carolina a few years back is the certificate of probable cause. This was one way in which Congress recognized that for reasonable mistakes, you wouldn't have to go, you wouldn't be held liable for them. And there are other doctrines and treatises providing others. So that if you look through the historical record, and Ann Woolhander's done a fabulous job looking through this and carefully, and her bottom line is much more, this is really muddy. Will's is, I think this is crystal clear or close to crystal clear. Ann's like, this is actually really muddy. And to give you just one example, Aaron suggested I read this one out. So this one is Wilkes versus Dinsmore, and it talks about from 1849. It says, "It is not enough to show he committed an error in judgment, but it must have been a malicious and willful error. And there are a number of other cases from the 1800s from the Supreme Court where they kind of focus on the idea that there's a reasonable mistake exception to liability for officers. Now, again, I'm not a historian. I'm not going to try to defend that. I have not spent the time reading all the cases. But I have read Will's article, and I've read a number of the cases, and I think it's much more of a mixed bag than Will suggests. Why does this matter? Statutory stare decisis. If it's not clearly wrong, we should leave it to Congress to fix it. It's been around for a long time. And that's really the point I'm trying to make, is that this is a doctrine that Congress can address. There's not a clear error here along those lines. The third argument or point I want to talk about is a course correction, and Will kind of eloquently kind of set this up. When I teach constitutional litigation, I always explain to my students that Congress and the Supreme Court have tried to create a balance of policy interests through Section 1983. So on the one hand, Congress says in Section 1983 that an officer can be liable when acting under color of any statute, ordinance, regulation, custom, or usage, state law. They also in Section 1988, so that limits the liability. You've got to be acting under the color of law. But then they also incentivize lawsuits in Section 1988 by providing attorney's fee shifting statute. So Congress has tried to tinker with it to encourage litigation, encourage lawyers to take the cases, but to narrow the scope of that, right? And so they're carefully aware of trying to strike this balance, this policy balance, when it comes to constitutional litigation with respect to monetary damages from state officers. Congress has also tinkered with these provisions over the years, both Section 1983, as I mentioned before, by addressing judges, and Section 1988 by clarifying how the attorney's fee shifting statute works. So they're well aware of how these statutes work and try to create the right balance. The Supreme Court has also tinkered with the statutes. I think kind of most prominently is municipal liability. Originally, they said no liability in Monell, and they turned around and said yes liability, but only for certain policies, official policies or informal policies, and no punitive damages. So the Supreme Court has been trying to strike the right balance for municipalities. I kind of put a footnote here. That municipal liability standard looks a lot like what you might have if you don't have Monroe v. Pape, which I'll get to in a second, for individual officers. They've also, of course, the subject of this debate, right, qualified immunity. 1967 in Pearson v. Ray recognized a good faith exception for that, which they then modified in Harlow and the like. Now, I say this because this is a very complicated system. We're tinkering at the edges to try to create the right balance of policy, and I'll get to the policy arguments in just a second because I think they're important to underscore why we have qualified immunity and why we want Congress to be the one that actually makes a dramatic change to it. But we do get to Monroe v. Pape, the 1961 decision, which Justice Scalia colorfully said converted an 1871 statute covering constitutional violations committed under the color of state ordinance, regulation, custom, or usage of any state into a statute covering constitutional violations committed without the authority of any statute, ordinance, regulation, custom, or usage of any state. Now, I think Will and I probably disagree. I don't think this is a crystal clear. I'm not entirely sure Monroe v. Pape is wrongly decided, but I'm probably more inclined to say that it is than Will is. But the bigger point here is that's a 1961 decision, and Pearson v. Ray came 6 years after. Will's reading of that is that they invented qualified immunity to kind of counteract a mistake they made in Monroe v. Pape. I think that's a plausible reading. Another reading of that is that Section 1983 was seldom used before Monroe v. Pape. We never experienced the immunities that would apply in these contexts until we had Monroe v. Pape and this avalanche of cases coming forward. And at that point, the Supreme Court had to look back and say, well, what immunities would apply if a state officer abused state law? Well, it turns out that there are a number of Supreme Court cases that say that reasonable mistakes don't apply. And so you see this kind of more historical argument saying that this isn't a course correction. This is not another wrong. This is a chance to try to bring it back to original understanding. Again, I'm not a historian. I have not spent a lot of time in the 1800s cases to really kind of nail that down. But I think that's kind of the stronger argument along those lines. So if we're thinking of discarding qualified immunity, and I'm going to look into the camera because I'm speaking to Justice Thomas right now, because Justice Thomas is interested in this. I would say, Justice Thomas, reconsider Monroe v. Pape. And you'll end up with a very different scheme that actually might look quite similar to what we have today by tinkering, by changing those two doctrines. Now, Justice Thomas, don't get rid of either. Let's let Congress do that. I think I'm going to skip over the policy rationales because I got 2 minutes left. Actually, no, I'm going to hit on two. When Harlow explains the reasons for the policy rationales of why we have qualified immunity kind of identifies for litigation costs for individual officers, opportunity costs that officers are in court instead of out there executing the law, discouraging officers from being officers so we don't get the best public service that we have, and discouraging officers from making hard decisions when the law is unclear in order to effectuate state policies, right? Those are kind of the 4 reasons. Federalism isn't mentioned there, but I think it actually is in the backdrop because we're trying to implement state law and we're trying to, it's individual officers, at least as legal fiction, are the ones that are paying for that, right, out of pocket. We know now today from Joanna Schwartz's work that state and local governments cover 99.8% of all of these litigation costs. So it really has become much more of a federalism issue than it was in the past. And I want to kind of flag that now because Will at least hinted that we might be talking about Wayfair in a little bit and kind of say that there is a huge states' rights issue, especially today with state and local governments paying the bulk of this. The unfair notice arguments and the comparisons to the criminal ones, I would just quickly respond and say, like, 1 wrong does not make it 2 wrongs, right? Like, just because criminal law does not take that into account in every context, or they do in some contexts, it doesn't mean we should mess up qualified immunity as well. And then the last thing I just want to kind of end with is, I'm not giving you your shiny, brand new libertarian judicial philosophy here, right? This is your crusty old conservative judicial philosophy of Article 1 and state statutory stare decisis. If there's an error in a statutory interpretation that's existed for a half century, we should entrust Congress to make that decision. That's particularly important in the context like this, where states' rights are so at play and the balance between the state and federal government powers are so at play. And to kind of just give you one example from Joanna Schwartz's work, and I'll end with this, she did a study, looked at all the decisions from 2006 to 2011, all the settlements and disposals of cases. And 44 of the largest police departments spent $730 million resolving civil rights litigation. That talking point writes itself at Congress, right? There's no way that Congress is going to want to open liability to already financially strapped cities to cover even more instances of potential constitutional violations, especially when those ones are ones that were done in good faith. That's just not the realm. Now, that might be like, well, this is convenient to rely on statutory stare decisis. If that's a wrong, we should correct it. But I don't think it is. I think this is an issue that if we want to address it, Will's proper argument is not one to the Supreme Court, but one to the Article 1 branch to Congress. And I'll end on that.
All right, I have 5 minutes. History. So yes, it's complicated, and I think if you read the hundreds of pages of history, I think the strongest criticism you'll get is something like, at the founding, there was a pretty clear rule that executive officials who violated the Constitution could be held liable. Over the course of the 19th century, this got much more complicated and eventually metastasized into the things that we now know as modern immunity doctrines. I think even on the most sympathetic readings, it's hard to say those doctrines were well-established common law by the time 1871. There are some judicial decisions by 1871, and there are some others that go the other way. But which way they cut, it's hard to say it had anything like the same status as the idea that for judges you're supposed to appeal rather than sue them. Legislators are not personally liable for the statutes they vote to pass, the kind of classic immunities. I think that's go much further in detail about it. I do have to just sort of to bookend it with a couple of examples. So in 1804, the Supreme Court had the case of Little versus Bareem, aka the Flying Fish, where a naval captain improperly seized a boat that was not subject to the French embargo, because the embargo was actually sort of confusingly written, and applied only to ships going in one of the 2 directions, not the other direction. Anyway, he was personally sued and held liable, and Chief Justice Marshall wrote the opinion for the court upholding his liability. And Marshall admits in the opinion that's ultimately reported that when he heard this case, the first bias of my mind was very strong in favor of the opinion that although the officer's mistake could not give a right, they might yet excuse him from damages. But he says, all of my colleagues convinced me that's just wrong, that's not the law. When you violate the Constitution, you've got to be held liable, and that's that. That's 1804. 1915, a few decades after Section 1993 is enacted, the Supreme Court has another case, Myers versus Anderson, a voting rights case, where the officers actually try a version of this good faith defense. They say, The statute was enacted against the traditional rule that good faith mistakes, you can't be held liable for. The court says, look, your contention is fully answered by the terms of the statute. And they affirmed the lower court decision that had said, the common sense of the situation is that anyone who enforces an unconstitutional statute does so at his known peril and is made liable to an action for damages by the simple act of enforcing a void law. Now, so I don't know all the history either. I don't have a PhD in history, but the court in 1915 is a lot closer to the situation than Chief Justice Warren was in 1967, than the court was in 1982, or than either of us is here today. So I'd be happy to concede the debate if we could just get a fair hearing in the Supreme Court on the question of whether it's historically grounded. I'd take a cert grant and be happy to see what happened. But that brings us to the question of whether or not the court is the right forum for any of this, or whether we should go to Congress. So there's an idea that stare decisis is very strong in cases of statutory interpretation. But normally that's a case where the statute says something, and then the courts interprets what the statute means, and we decide we'll stick with that and let Congress change it. Even on the most sympathetic account, qualified immunity does not even purport to be an interpretation of what any of the things in Section 1983 actually mean. It is an articulation of other doctrines outside the statute that supposedly justify ignoring the statute, either a background historical rule that turns out not to exist, a constitutional mistake that may not be a mistake that might justify sort of a reinterpretation of the statute, or again, a non-textual principle like the rule of lenity, which might apply to a civil statute and then reinterpret. There's actually no statutory interpretation that the court is even purporting to do in its qualified immunity cases. So it seems like an odd case for the statutory interpretation gets strong stare decisis principle. Maybe it's not a coincidence that the court has monkeyed around with various aspects of Section 1983 so much, from municipal liability to the procedures to the articulation of the rules. I think they treat it a little differently. Now, yes, Congress could fix it, just as Congress could fix any, say, Dormant Commerce Clause decision, where if there's some dispute whether a state rule is authorized or not, Congress can step in and change it. Last term in South Dakota versus Wayfair, when told that they should leave a Dormant Commerce Clause decision in place because Congress could fix it, the court said, it is inconsistent with the court's proper role to ask Congress to address a false constitutional premise of the court's own creation. We have acted as the front line of review in this limited sphere, and it is important that our principles be accurate and logical, whether or not Congress will or should act in response. The last thing I'll say is that even if you put all that aside, a fundamental rule of stare decisis is that when underlying facts, circumstances, and premises have changed from the time a rule was enacted, then also it might be time to reconsider the rule. In 1967, when the court started us on this journey, the court was in the business of aggressively recognizing a whole bunch of new constitutional rights. It was the anti-Jim Crow imperative. So maybe it's not a surprise that they needed to adopt some doctrine to soften the impact of all the new constitutional law they were creating, recognizing sort of the massive upheaval they were going to be posing. With all respect, I think that era is over. I don't think the court is, the court has recognized a few major constitutional rights the past couple of years, but the Warren Court has left the building. And instead of the anti-Jim Crow imperative, we have something like the new Jim Crow, where we have a lot of abusive police practices that everybody recognizes are wrong and often unconstitutional. And qualified immunity contributes a great deal to making sure that none of them go checked, even when many of them would have been common law suits actionable in every court at the founding. And that seems to me to be a problem.
All right, so let's talk a little bit about Little versus Barrymore, which I reread last night, just for fun. Wow, they're hard to read, those 1800s cases. That's a different writing.
It's short.
It is short, and it doesn't really tell us much. It doesn't, as Aaron and I say in our essay, it could be quite plausibly that Chief Justice Marshall was deciding that it was not a reasonable mistake to seize the ship, that the statute was clear, there was nothing there. And so we don't really know there. I don't think that's that strong. And in fact, if you fast forward just a few years, in United States versus Riddle, another case dealing with the certificate of probable cause, the court comes out the other way. And let me give you a nice quote. A doubt as to the true construction of the law is as reasonable cause for seizure as a doubt respecting the fact. I don't want to try to prove that Will's wrong on this. I don't know, and I don't need to, because we have stare decisis here to kind of sort that out. But I do think that's there. And that's something that's important. Now, as to the kind of arguments about it needs to be clearly established at the time of the founding, and that this isn't really a statutory interpretation, it's something else. I'll confess I'm just confused by that. It's a general principle of statutory interpretation that we incorporate the backdrop common law. I think it's pretty well established. Will and I can have a debate of whether to get rid of absolute immunities next, because apparently they're not in Section 1983 either. And I'm happy to have Will try to carry that water. That's a hard one, because those were really, really clearly established when the Civil Rights Act passed. So I just don't buy that. This is interpreting Section 1983. Now, I think where Will runs into some problems is, of course, qualified immunity doesn't just apply to Section 1983, it also applies to Bivens suits. And the question there, of course, we don't have statutory stare decisis in Bivens suits. I don't know what to make of that, right? It's not as strong. I'm guessing the Supreme Court's not going to be revisiting Bivens anytime soon to expand potential liability. And so they're going to run into a problem at the Supreme Court if Will makes the argument, as he's making right now, that this isn't really a statutory interpretation question. This is something else. Well, then if this is something else, we have to change the Bivens qualified immunity standard as well. And good luck with that. Now, as to whether it's Congress or the courts that should be dealing with this, I don't think I have much to add. This is a doctrine that's been around for a very long time. I think if you polled members of Congress today, there wouldn't be much enthusiasm to get rid of it entirely. And I don't think that's really where it's at. I think the reason that we're going to the Supreme Court is because that's the most likely path to at least get a hearing on whether we should get rid of qualified immunity, because at least a couple justices have expressed some interest in it. That to me, that's not how it should work. When it comes to reinterpreting statutes that have been on the books for a long time and precedent that's been around there for about 50 years, we should go to Congress and have that debate, especially in this context where the policy considerations are so important, where you have state budgets at issue, when you have the enforcement of state laws at issue, that you really do need Congress to be weighing the proper balance between compensation and over-deterrence. So
I will thank you to both debaters for fascinating openings. So I want to start off with some questions about stare decisis. So for Will, should the Supreme...
I forgot the wafer stuff. I'll come back to that.
Should the Supreme Court be open to overturning any precedent that it currently views as erroneous, or are there some reasons to keep a precedent? And related to that, for Chris, when should the Supreme Court decide to overrule versus not overrule? Now, my understanding is that you're not a huge fan of some doctrines in administrative law called Chevron deference and Auer deference, and that you've been in favor of overruling those. And I'm wondering how you make the distinction here between qualified immunity and those doctrines.
Yeah, so I don't have a well worked out theory of stare decisis. I think there is a very respectable argument that anytime the court is really convinced that a doctrine is wrong, not just kind of sure, but like convinced beyond some substantial burden of proof that maybe I failed to carry today, that it ought to fix the constitutional problem, that might be right. There's some historical arguments that maybe there are special cases of reliance interests for especially areas of property or contract law where we try to sort of actually run a real system where there's a stronger stare decisis principle. I'm open to that. I don't think those would really justify qualified immunity either. But I do think that it's important not to engage in special pleading or sort of isolated demands for rigor. So just since Chris mentioned Bivens too, the Supreme Court has a case called Bivens in which it has recognized a non-statutory cause of action against federal officials. And the Supreme Court has demonstrated about as much disrespect for one of its own precedents as you can without explicitly overruling it. Having failed to recognize any Bivens cases in my lifetime, and come close to saying that they're never going to. They've got a couple cases that were all decided before I was born, and maybe they won't overrule them. And in the most recent case, the court even said, look, this is a doctrine that we created, it didn't come from Congress. These kinds of rights and immunities really should come from Congress. It's not our job, so we better kind of narrow this previous precedent of ours, making up a non-statutory rule in this area. That doesn't have any basis. Now, by the way, we strongly believe in qualified immunity, about which all those same things are true. Yeah. And it seems to me that whatever the answer is, it shouldn't be able to do that.
You have just made me feel very old. Chris.
So let me circle back to wafer, since that was the one point. I think it is inventive on Will's part to bring up wafer. Of course, that is a constitutional precedent that interpretation of the Constitution is overruled. And one of the reasons they did give was, they did say we give special weight in this context because Congress can always change the floor. And that's true. States' rights were at issue, and that's why they overruled it. I don't think that helps me or hurts me that much in the context of statutory stare decisis. And in fact, when you consider the states' rights issues at play today with qualified immunity, I think a lot of Wafer actually supports the idea of leaving this to Congress. Now, as to like theories of statutory interpretation or statutory stare decisis, I definitely buy in, unlike Randy Cozone, that there is a difference between constitutional and statutory stare decisis, and that it matters a lot more in the statutory scheme than it does. And I would generally kind of follow kind of traditional things of reliance interests, which I think the reliance interests here are quite great with how governments have set up by statute and contract indemnification agreements, for instance, at the state level. But I don't view that as like at the constitutional level. And now you're killing me on. I'm not someone who's on the record for getting rid of Chevron deference. I'm skeptical of Chevron deference, but one of the reasons I think it's a heavy lift to get rid of it is because of statutory stare decisis. I think Cass Sunstein most recently made a pretty good response to Aditya Bonsai and others who've said that there's no historical foundation for it when the Administrative Procedure Act was enacted in 1946. I think it's a close call, and if it's a close call, that's something that Congress should resolve. I'm probably more bullish about getting rid of our deference, because maybe I'm now backtracking on my point about Will. I don't really see it as an interpreting, I don't know where it comes from. I don't really view it as coming out of Section 706 of the Administrative Procedure Act. I don't know where it comes from. But more importantly, in getting rid of it, I would generally view as replacing it with another deference doctrine that's more in line. This is going off Jeff Poshnowski's work and with more in line with what the deference doctrine looked like in 1946. So I don't necessarily want to get rid of it entirely. I think stare decisis, if you pushed me hard, would get me to say, let's at least return it back to its kind of original understanding of 1946. But I too don't have a worked out theory of stare decisis. I'm a simple administrative law professor that works along those lines.
So my next question, there have been a few comments about how maybe Congress should do this rather than the U.S. Supreme Court. And I think an interesting question is, what would be the source of congressional authority, in your view, for enacting qualified immunity for federal as well as state and local officials? Because this would be a very complicated, one could say the Commerce Clause, although I'm sure people in this room would debate that. So necessary and proper clause, but attached to what? Would it be attached to the judicial power? And if so, does that mean the Supreme Court already has the power? Section 5 of the 14th Amendment is a possibility for states and localities, but it's not clear that that's enforcing the 14th Amendment. And so I'm wondering, especially when it comes to the Constitution, how could Congress do this in your view?
I think this is like 3 levels above where I can think. I mean, my response is, I thought this was simple. Maybe I'm missing it. I mean, it would just be redefining the types of liability under Section 1983. It'd be narrowing the scope of Section 1983. And that would be a problem because, they've already done the Prison Litigation Reform Act. They've done a number of different contexts.
So
maybe jump in.
So take federal officials. So Congress has the power under the Necessary and Proper Clause to make all laws necessary and proper for carrying into execution the powers granted in other branches of government. So presumably Congress would say, part of our helping the executive branch carry out their powers is to give them qualified immunity and ensure that judges aren't bothering them too much with constitutional lawsuits that get in the way they're doing their duty. And maybe tell some similar story with enforcement power for states. Now the tricky thing, and I think this is why this is a helpful question, is qualified immunity only operates in cases where the executive is doing something unconstitutional or the states are doing something unconstitutional. So it's a weird time to talk about states' rights when the only time the doctrine bites are in things that are actually not the states' rights, things that are outside the state's power and belong to the people, things that are outside the executive's power and belong to the people of the states. So it's a funny kind of doctrine to say part of our correctly enforcing the powers of the states and the executive branch will be to ensure that they can sometimes do things that are illegal. Now, I still think you can probably get there by saying, it's not the suits it's not the, suits that are correctly decided we worry about, it's the wrong suits. You need to have a sufficiently big zone of protection because we don't know which cases are going to be right, which cases are going to be wrong. But I do think when you try to bring in the separation of powers or federalism for a doctrine, its ultimate purpose is to allow the other branches in the states to do illegal things by hypothesis. There is something kind of fishy there.
So inside baseball, you guys have referred a little bit to Bivens actions. For those of you who are not living in the world of federal courts, this was a doctrine created by the Supreme Court in 1971 to allow individuals to sue federal officials for constitutional violations. And Will has mentioned that the Supreme Court has really pulled back on that doctrine over the years. But what I haven't heard is whether, assuming Bivens stays in place and potentially even becomes stronger, is qualified immunity more acceptable in that context, or less acceptable, potentially, as opposed to in the statutory context?
Yeah, I mean, I'm more acceptable. I'm trying to figure out what I mean, because my thoughts are going to Monroe v. Pape as well, right? Like,
so the idea being that if the Supreme Court created the liability to begin with, can it also create
so, like, if you're removing like Monroe v. Pape, for instance, and you're removing qualified immunity, I think that for me that's a better way to think through that. At least to kind of work through that puzzle, is that then you might end up with a system that's more consistent, because you are really getting back to basically what we have with municipal liability in a lot of ways, right? But in the Bivens context, I mean, I think Will's point, I mean, it's so limited at this point that.
Yeah, so here's what the court has said, is that when they decided in Bivens that they were going to create a federal cause of action for damages against federal officers, I understand the logic. It's something like, well, Congress created one for states, no good reason to have one for states and not for the federal government, so we'll create one for the federal government to match. And I guess there is a kind of matching principle. If the Supreme Court's going to invent a statute, they may as well invent one that's the same as the actual statute that we have for states. So then it makes sense for the two immunities to be the same. We've got like a real statute that applies to states and an invented statute that at least has the virtue of being very similar to something that actually exists. So I'd be inclined to treat them both the same, but certainly I'd be happy to trade. I'd be happy to overrule Bivens and overrule qualified immunity and just enforce the actual statutes we have. The one irony of overturning Bivens is after Bivens was decided, Congress enacted the Westfall Act, which immunizes federal officials from state common law torts, which was the way they were actually held accountable for most of the country's history. And in doing so, Congress expressly relied on the availability of Bivens causes of action as one of the reasons to do so. Now, since then, what's happened is we have the Westfall Act, which stops officers from being sued at common law. And then we have the elimination of Bivens quietly by the court, which stops federal officers from being sued for constitutional claims. So in practice, now we have neither. That's probably not right. And I'd be happy to reconsider that one too. I think Steve Vladeck and Carlos Vasquez have a good article pointing out this sort of contradiction. But one problem at a time.
All right. Well, I'm sure there are people in the audience that are absolutely eager to ask questions.
Tara's got another 3 pages of questions to keep us going.
I do. Jack.
I just want to say, Will, I'm totally 100% in agreement with you about enforcing statutes. I think it would be very surprising if you could get a group of the Federalist Society to say that we should not enforce statutes as written, and we should instead rely on stare decisis, because of what Congress said. But do you think then that it should be done on a state-by-state basis? Because of course the Congress in 1871 also said that issues like this that aren't covered by the text of Section 1983 ought to be decided under the common law of the foreign state. So want to go all the way and enforce the statute, or do you think that insanity, we should ignore that insanity? 1988A. The other thing I would say, I just want to respond to something about the Bivens thing. Remember, most Bivens cases now are covered by the Federal Tort Claims Act. So we don't need Bivens anymore, because during the Reagan administration proposed overruling Bivens and expanding the Federal Tort Claims Act. They got half of what they asked for. They got the expanding the Federal Tort Claims Act, but they didn't get rid of Bivens. We don't need Bivens anymore. We have the Federal Tort Claims Act to cover that. So I'm very surprised at the idea that we should rely on stare decisis when we've made an obvious violation of the actual text of the statute. But I wonder, what do you say about then doing it state by state, since that's what Congress said in 1871 in the provision now that's codified in Section 1988A? Yeah.
No, this is great. So Section 1988 says that things not dealt with by Section 1983 and other statutes are left to common law, to state law.
Of the forum states.
Of the forum state, yeah. So I do think, I guess 2 things. I don't think that's as insane as probably most people do. I think it'd be fine to leave a lot of procedural issues to the foreign state. I do think we have to figure out a little bit, like in a kind of reverse Erie type case, about what things are within the scope of that and what things are resolved by Section 1983. And I don't think states could concoct absolute immunities and then get them into sort of using the Section 1988 escape hatch. I do think trying to figure out how that statute is supposed to work in a Swift versus Tyson pre-Erie world, especially given the reference to the state, is a little bit of a trip to another country. that I'm happy to undertake, but I think it'll look a little more complicated than we envision. Because in a pre-Erie world where a suit's brought in federal court and you've got a federal court's independent analysis of what state law requires, it's not going to be nearly as crazy as it would now seem to us. So we have to decide exactly how far to go. And maybe Erie is an example of one of these cases that's wrong, but we should keep anyway for reasons of stare decisis. And if so, it might make this whole thing.
We found a case. I will say real quick on the FTCA one, that's not like, to me, a very adequate substitute when you have the discretionary function exception, and I mean it's got a lot of exceptions in there to me that make it seem a lot different than.
Better than nothing.
What?
Better than nothing.
All right, we'll go to our next question.
Hi, again, I'm Kevin Douglas. I'm at Scalia Law School. Thanks for the presentation. I'm hoping you guys can clarify the scope of cases you guys are talking about and not talking about. You guys are regularly talking about government officials who are accused of violating the Constitution in some way, shape, or form. I'm curious as to whether or not there are other acts or violations that these guys can engage in that are not considered constitutional violations and therefore outside the scope of qualified or some other kind of immunity. And in particular, in my mind, I'm thinking about, whether or not, I have no idea whether this is within or without, but on the one hand, prosecutors and police officers being able to lie to someone who's being investigated in order to get confessions, but that's not like a misrepresentation or something else. How is that in or out? And when it comes to administrative law, what specific kinds of claims are being brought against administrative officials and what are not? Because I'm not sure what's.
I guess so I think we're talking about suits for damages. So a lot of administrative law ends up dealing with what's effectively forms of declaratory or injunctive relief, telling agents what to do or not to do. There are sometimes suits for damages under other statutes. People bring them under the Religious Freedom Restoration Act. Various federal statutes create them. Now, interestingly, the court has applied qualified immunity, or lower courts especially have applied qualified immunity there too. So it's not just stare decisis, keeping it where it is, but it's spreading to the rest of the U.S. Code as well. I think those are part of what we have in mind. But neither of us necessarily is talking about criminal punishment for officers who engage in witness tampering and lots of other illegal activities. Which
I mean, it obviously does apply. It's not just to constitutional claims, but also to other violations of federal law, and that's super complicated. And I limit that to one day in my class because otherwise it gets really, really complicated.
All right. So if I think the Warren Court was wrong to incorporate the Bill of Rights, because I think it's a textual or a historical, if I'm someone who thinks that just as a hypothetical matter, and if I simultaneously recognize that it's utterly hopeless to think the Supreme Court would ever overrule those precedents, then shouldn't I wholeheartedly embrace qualified immunity, even if I agree with everything you just said, Will, that qualified immunity is atextual and contrary to the original understanding, because it serves as the perfect compensating mechanism in this second best world that we live in. Do you have anything to say to people who think that, other than to say that you're wrong, to think that the Warren Court was wrong about incorporation?
No. So and the question of when we should have these kinds of second best, two wrongs make a ruling, two wrongs make a right rules is really hard, and somebody needs to solve it. And I hope it's somebody smarter than me. But here are a couple points of skepticism. So one is, if that's your reason for justifying qualified immunity, it is a reason that probably applies to nobody on the current Supreme Court. So even Justice Thomas, who doubts the incorporation of the Bill of Rights under the Due Process Clause, has written extensively about why it should be incorporated into the Privileges and Immunities Clause. Recent comments by Justice Gorsuch suggest he's probably got a similar view. So if we could agree that qualified immunity is correct if, but only if, incorporation was wrong, I'd be very happy about where that would leave us. It is also a funny kind of compensating adjustment, in part because it only applies to claims for damages. So one consequence of that world is while police officers can't be directly sued for a violation of whatever constitutional right, we can still have massive, aggressive structural injunctions against every city and state in which the judges end up running major portions of school, prison, whatever it is. And if you think incorporation of the Bill of Rights is wrong, I'm not sure that sort of status quo should leave you that happy. Now maybe it's a little better than it could be, but I don't think it's the perfect compensating adjustment by any means, and it might actually distract us from what, in your view, would be the real constitutional problem.
So what I hear from Will is that yes, that's what I heard. we should want to keep qualified immunity.
So, contrary to our first question that you got, I sympathize, Chris, with the idea of statutory stare decisis, and certainly that principle of judicial conservatism over the text of the statute. That said, it seems to me there's a problem with one of your arguments, and I just want to sort of puzzle over it with you and with Will as well. It has to do with the expectation that Congress will or should act in these contexts. So a lot of this debate takes place against the backdrop of the following fact. Congress could revise or preserve qualified immunity by statute in ways that address both Will's arguments and yours. Congress is free to act here. But there are these two sort of obstacles. One is that Congress is just very passive in the face of these forms of, these questions of judicial procedure. And second is that Congress's behavior is very predictable because of the interests arrayed here. The plaintiffs are very unsympathetic in these 1983 cases, and so many of them are criminal defendants or inmates or suspects. Not all, but so many. And second, that the price tag is so high if cities and states and localities should be exposed to these suits. So we know that Congress will probably do nothing, but if they do something, they will preserve or expand qualified immunity. Is that an argument for the courts to be more active, and for an argument of Will's form that courts should take the lead in correcting this doctrine if it's wrong, or is that an argument in favor of leaving the doctrine as it is because it probably reflects Congress's will?
Yeah, that's a tough. I get nervous whenever I'm trying to guess what the current Congress would do or not do. But I mean, I think you're right. Although with qualified immunity, it has gotten a lot of popular attention, right? Justice Stevens, it's one of his 6 amendments to the Constitution. Dina Chemerinsky has gone on in op-eds across the nation. I do think there is a mobilizing power around it, perhaps, that if the right election comes through, there would be some type of reform. It's not going to be get rid of qualified immunity. It would be something different. I don't necessarily think it necessarily expand it, but there'd be something there. But I think this is why we have statutory stare decisis. This is a statute. It's not it's not a constitutional provision. It's not the court trying to figure out what's the best policy to address the right portion of the population that's being harmed. I just don't see that as the role when you have a statute that's been interpreted for over half a century. That really should be. It's in Congress's court if they want to change it. I don't know. Will you disagree?
So I guess I think we agree with this, which is people like to say that courts are bad at doing history. I think they're even worse at telling the future. Yeah. So I don't think the courts should do anything based on their predictions and how the game will, if we did X, Congress would almost certainly do Y, and therefore we should do Z or X prime or whatever it is instead. So I think courts should just worry about doing what they think is right and letting the chips fall where they may. And I think the reason this is hard for some people is that we have 2 different norms of what's right. One is applying precedent, and the other is applying the law. And if precedent misinterprets the law, then you have a conflict about when do you cling to a precedent that's arguably mistaken about the law. But I think that's the thing courts should be wrestling with. And the courts should not feel embarrassed if they issue some qualified immunity ruling and then Congress decides it wants something else. That's separation of powers.
Yeah, I mean the law is the statute and passed by Congress, and I guess and that's why I think the wafer analogy is somewhat flawed. Is that sure, if we're interpreting the Constitution, it's a different set of considerations. But when you're interpreting the statute, the law as it's been interpreted. I don't know. Maybe Congress can reconsider it.
So, Evan Bernick, Georgetown Law School. I have a question for Will and I have a question for Chris. Will, why is Section 1983 not like the Sherman Antitrust Act? Why does it not delegate to judges the power to define in a common law fashion the extent of official immunities? In which case, even a textualist like Judge Easterbrook would say the ordinary rules of statutory interpretation, if they don't not apply, they apply in quite different ways. Chris, if somebody from Senator Kamala Harris's office reached out to you and said, hey, I read Justice Sotomayor's dissental in Mullenix, and I want to do something about qualified immunity, where would you be prepared to meet Will halfway with respect to drafting new statutory language that could temper some of the excesses of qualified immunity?
Great. So 2 things. So one is, well, the court certainly doesn't say Section 1983 is a common law statute. they say things like, we are not licensed to engage in freewheeling policy choices, where we put in whatever kinds of immunities we want. We have to always get them from history or from the kind of the ordinary sources. So it's not, it's not the court story anyway. And I think if they were to admit that they were doing this all themselves, then they'd presumably have to actually talk about whether what they're doing is good policy or not, and what kind of incentives we're creating, and they don't want to talk about any of that. I will say, everybody always throws around the Sherman Antitrust Act, and I just have to ask, are we sure that the Sherman Antitrust Act was adopted as a delegation of courts to make economic policy for the nation? Because when you look at the statute, and when you look at, as far as the legislative history I've read, it's not so clear that that's true. It seems more like it was a very short statute that on its face seemed to say something that a lot of judges thought couldn't possibly be true. And so they thought, well, surely this is only supposed to do things that are reasonable, and surely we're the ones to decide what's reasonable. And then the next thing you know, we're sort of off and running. I mean, I'm really not an antitrust scholar. I'm just a simple Fed course scholar. So maybe this is all totally fine. But we're so sure.
I like Evan's question to me, not to you. You can handle that one. Because I think it does raise certain issues that we're not talking about, which I think most of the public attention to policy debate has been about, right? Not what it is, but what it should be. And I see a number of different things. One, I definitely don't like the way the court has been requiring like strict, identical facts as prior cases. I think the Hope v. Seltzer, although not perfect, is a little bit better approach, right? Where it's more analogizing, saying, more of a fair notice approach, right? Like based on existing precedent, would the officer likely have known, right, that this was unconstitutional, not known for sure the same exact facts. So I think that's one way that you can do that. And I'm actually probably, as a policy matter, I think Harlow could be removed, right, and insert back a subjective test. And one reason I think that works, especially today, is we have Twombly and Iqbal now. With heightened pleading standards, you're going to have to have a plausibility that it's not just. And so I'm not as concerned about getting cases out of, into discovery as I might have been when Harlow was decided, 35 years ago. So I could imagine that. One is try to signal to the court, the standard is not exactly the same set of facts apply. It can be just general kind of fair notice. And two, reintroduce the subjective intent as a secondary prong that could get you into discovery. If you were drafting a statute, I'm curious, you would just get rid of it entirely?
No. So here, I'd say there should be immunity when an officer acts in reliance on a precedent that has since been overruled. So if you acted in reliance on Baker versus Nelson, which said that there was not a federal constitutional right to same-sex marriage, you shouldn't be liable, even though now Obergefell said the opposite. I'd be open to a similar rule for statutes, that if you were enforcing a federal statute, or the federal statute requires you to do something, and no court had yet held it unconstitutional, there could be some kind of reliance. But something where the executive officer is relying on the constitutional judgments of somebody other than themselves. The current regime where an officer just makes a mistake, or sometimes not even a mistake, sometimes there is evidence of malice or bad faith, and then says, well, yes, what I did was unconstitutional, I can't even come up with an argument that it was reasonable, but it was kind of reasonably unreasonable. I think that whole zone would still.
You would like OLC opinions, or like opinions from agency heads, or from...
Better.
Interesting.
Thanks. I have a methodological question, which is a spin on Evan's question, which I guess is, why does the court think, as a matter of judicial power, that the history matters at all? In the sense of why, this common law of immunity was in a state of evolution. Why do we presume when Congress enacted the statute in 1871 that it intended to freeze the common law in place, as opposed to letting courts continue to tinker with the common law doctrine as they had before? In other words, aren't these immunities just sort of sub-statutory backdrops that courts can change in a way and don't have to be considered baked into the statute itself? And I guess from the judicial power why doesn't that work under our conception of judicial power or other structural constitutional constraints?
The judicial power is the power to find law, not the power to make it. So, and that was certainly true before Erie, and probably is still true now. Erie, not to the contrary. So I think probably the assumption was even when judges are doing common law rulemaking, even when they're revising the common law in light of wisdom and experience, what they're always doing is applying some set of pre-existing principles, not making it. And this idea that courts can make law, I think, is a modern and nefarious invention.
So, Will, let me just interject there. So, for people who think that courts actually do make law, which is a good portion of the legal world, then does it follow from Elon's question that it actually, the Section 1983 did not freeze anything in place, and it's fine for courts to be moving things along in a common law type of way?
It doesn't follow. So I think one question is still, lots of people think, and maybe I do too, the courts do make law. That doesn't mean it's something they should be doing. It doesn't mean it's part of the judicial power. I mean, we might say it's something we've seen it done, but that doesn't make it totally constitutional. But even if you sort of follow your realism further than that, I think then we're always still left with this question. Well, so how do courts make it? And there, when the courts themselves are abjuring this kind of claim, when the courts themselves are saying, hey, it's we're just simple judges and it's not our fault, then I think it's especially an odd time for us to say, well, they're acting as lawmakers.
So this is just for Will. I'm hoping you can defend Monroe against Pape a little more. So bracket for a second.
I was hoping for a little bit more defense as well.
Bracket for a second what color of law usage means here exactly. 1983 imposes monetary damages on a person who deprives another of privileges or immunities secured by the Constitution. Those privileges and immunities secured by the Constitution all are against the state. So it seemed very weird to think that a person acting outside of any kind of state authorization is in fact depriving a person of a privilege or immunity secured by the Constitution. So I'm interested in medieval English law, but that seems to be a very different context. Moreover, the color of law here, that phrase interpreted in a way that's inconsistent with Monroe against Pape, fully maps out the kind of conceptual space. So you have people acting outside of color of law, of state law, are going to be subject to ordinary tort liability. People acting within the bounds of the Constitution have no liability. And that middle ground where the state purports to give the officer power to do something that is in fact unconstitutional is the gap that's precisely what 1983 fixes. That seems to be like a way more. I don't know if you need any kind of exhaustion rule but conceptually it seems to map perfectly there. So I find your skepticism about Monroe to be weird and.
So once upon a time, this article was going to be basically what Vince just said. So once upon a time, I was seduced by Justice Scalia's theory in Crawford and Justice Frankfurter's dissent to say more or less this, that the elegant solution is to say there are officers who are subject to common law liability. They've acted illegally, we can take care of them. There are officers who violated clear law, we still take care of them. And this gray area of officers who violated some sort of law, but they're given an immunity, is the area we have to worry about. And Section 1983 is designed to address that and say, if they get immunity from the state, then they should get liability from the federal government. And that makes a lot of sense. It's very elegant. Justice Frankfurter's view, and then it's drawn on in a later article, a couple later articles that sort of that build it out. When you read all of the enactment of Section 1983 and the related civil rights statutes, there is not a hint of this there. And instead, there seems to be a widespread assumption and a specific description that under color of state law is designed to solve in a very common sense way this formal problem. That rather than being formalists about who is a state actor or who's not, they're like, look, the state is sending people around with all of the armaments and the de facto power of the state. And sure, in a technical sense, the state is violating the equal protection of the laws and due process. They're acting unconstitutionally, and therefore are they really still the state? As a conceptual sense, we wonder, can you be the state and still act unconstitutionally? But at a practical level, if the sheriff and the judges and all the people in town with power are going to lock you up in prison or shoot you, then...
Just to be clear, my concern is not that it's impossible for the state to act unconstitutionally. It's that it's impossible for an officer to act to deprive someone of a constitutional right if the officer is not actually empowered to do the thing by the state, since it's the state's clothing with authority to do the thing that is the violation of the Constitution.
Right. So just to follow the paradox one step further, right? So anytime an officer does something unconstitutional, they are in a sense acting without the power of the state, because the state can't provide them the power to do the unconstitutional thing under the Supremacy Clause, and therefore the whole thing sort of falls away. I guess I say this is a real formal paradox that I think is just solved at a very practical level by the way Section 1983 was enacted. And they may have been more practical, less formalist than either of us.
Of course, the alternative reading is under color of state laws to get around the kind of legal fiction that if they're violating the Constitution, state, and they're not being sued in their official capacity, it's a state action issue, right? I mean, that's the more plausible explanation of under color of state law is that you're still wrapping them in into their state action, even though they're not acting as state actors and being sued in their individual capacity. That's at least the way I think that a lot of us see it.
Well, I think the question was saying that Justice Frankfurter was right in Monroe v. Pape, that we should make sure the state as a whole is authorizing the action. Gene, were you in line for a question? Or? Then.
And it's a sort of unsophisticated one, but one of the things I'm not sure you've touched on, but not directly addressed, is the policy problem that comes out of this, which is, okay, you're a cop, you're in XYZ situation, you're doing the best you can, you kind of screw up, and there are two ways you can handle that. One is, well, the state's responsible for your screwing up. And second is, well, you really screwed up badly, you're responsible personally. If you take the second too far, it's going to make it much more difficult to get cops with any sense of personal danger, because in addition to the other risks they take that one. And if you don't take it that far, the state has the problem that, assuming it's got laws it should be enforcing, the expense of those laws could become unbearable, as with a couple of the hypotheticals we've had today about what if you expand in certain ways. Leaving, in a sense, off your pure legal hats, how does one handle the practical risks, or do you just think they're not that great?
So step one is indemnification. So I think the problem of being given an important job where lots of people are going to sue you happens not just to police officers, but to everybody who has to run a major private sector organization, let alone a publicly traded company. And what do? They negotiate counsel and indemnification. You get people to do the jobs, but the company ultimately decides to foot the bill. That brings us to your next version, which is that, so it's not going to be the officers I think we're worried about, it's the state. And there are going to be times the state looks at its bill for the stop and frisk procedure, or for enforcing sales tax against cigarettes or marijuana possession laws, and says, holy crap, this law is leading our officers to commit a huge number of constitutional violations, and those are very expensive. Is the law really worth it? And sometimes the state might be forced to either decide that a law is producing so many constitutional problems that it's not worth having, or, and this is often practically true, noticing that a small number of its officers are responsible for a huge number of its constitutional problems, and deciding it should do something to get rid of those officers, which will probably require it to fight the police union. Maybe that's a good thing. But I think both of those are actually healthy developments in our current sort of problematic municipal policies. I think the state taxpayers should have to pay the bill for really unconstitutional statutes. And I think somebody should be worrying about the small number of cops who commit a huge number of constitutional violations, who right now nobody does.
So I want to kind of build on that. Oftentimes, if my constitutional litigation students are watching this, they'll get an extra bump this year. But I often, as my policy question in the class, is how do you reform the system? And one of my kind of favorite answers, and there are lots of great answers, so don't worry if you don't get the right one, students, but is to get rid of indemnification and make officers have to get their own insurance. And that would be a lot of fun to see how the market responds to that. And obviously, you'd have to pay officers more so they could buy the insurance. But there'd be kind of interesting kind of dynamic there of letting the market sort out the bad officers from the good officers. And also keeping qualified immunity, but making them think a little bit more carefully. I don't know. I'm not saying that's the right approach, but it is an answer I like.
I would say so some of this does happen. So
Aaron's shaking his head no. I didn't try to get that in the article, Aaron.
So smaller cities often don't self-insure because they can't afford to indemnify everybody. So they do contract. You can get from Travelers Insurance Company actually a little bulletin on how to do a strip search. They distribute to all the insured officers in their program. One of my colleagues, John Rapport's done some work, and actually insurance risk adjusters have thought a lot more than probably anyone in this room about how to actually try to control constitutional violations and what kinds of training programs work and don't. And they're trying to do some interesting and surprising things. And there's some shooting simulators that actually work remarkably well, getting police officers to respond better in situations. Maybe it's not a surprise, I guess, to this room that the market might actually have something useful to teach us all about how to do something better than the government can.
The flip side on this, though, is on the indemnification side. One thing I loved, I used to always teach my students, was most indemnification agreements, either by state law or by contract, but they exclude punitive damages, and that's nice in the sense that it provides a kind of nice over-deterrence. Toronto Schwartz has kind of shown us that in practice that never happens, right? That they're still covered by the state. But I think that's another kind of nice way of trying to get out the really egregious conduct and set the right level of deterrence for officers from doing something along those lines. Is our time up, Will? Or I thought you were signaling to Tara there.
Well, I think that is a very nice place to conclude our debate. Maybe privatize qualified immunity.
There's an article to be written, not by me.
I want to thank both of our debaters for doing a fantastic job, and thank all of you for coming and asking such insightful and wonderful questions.
Thanks so much. This was so much fun.